Welcome everybody, good afternoon. Thank you for joining us for today's online talk, which will be starting right now. Today's online talk is entitled Landowners' Rights Against Trespass and Nuisance. And my name is Tommy Wong. I'm a senior associate with Vivien Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Hope you enjoyed the short little video from our firm. Now, Vivien Associates, we are a mid-sized law firm that was founded in 1985 by Dato' Vivien Fan. Our able team today comprises 28 lawyers and a support team of 30. Dato' Ma is today a consultant with the firm following his retirement from the Court of Appeal bench back in 2015. The firm continues its tradition today by working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment and industrial relations team, and a department focused on servicing the needs of families and individuals. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly talks at our office since 2013, some of which were also broadcasted live. But due to the COVID-19 pandemic and MCO, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and also in-house counsel. This is our 19th talk in our online talk series in 2022. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary consultation, and the details will be given at the end of this talk. We have two speakers for today. Please allow me to introduce them. The first speaker is Ms. Vivien Fan. She is a senior associate in our dispute resolution department and the department servicing individuals and families. She graduated with a Bachelor of Laws from Cardiff University in Wales, United Kingdom, and she was also called to the English bar back in July 2016. After she completed her pupillage, she was admitted to the High Court of Malaya back in 2017, and now her areas of practice include criminal litigation, land acquisitions, general litigation, debt recovery, probate and administration of estate, contractual disputes, and also tenancy disputes. Our second speaker for today is Mr. Eric Toh. He is also a senior associate in our dispute resolution and individuals and families department. He graduated with a Bachelor of Laws from Australian National University, and after completing his pupillage, He was admitted to the High Court of Malaya in 2018. His main practice areas include general litigation, focusing on family, citizenship, adoption, defamation, land acquisition, and strata disputes. If you have any questions about today's talk or as the presentation is ongoing, please do not forget to type it up in Zoom's Q&A chat box, and these questions will be addressed at the end of the session. These are our talk points for today. Ms. Vivien Fan will be speaking first on understanding the law on trespass and case studies on trespass, and thereafter Mr. Eric To will present on private or public nuisance and also case studies on nuisance. With that being said, ladies and gentlemen, I would like to pass the floor to Vivien, who will begin her presentation right now. Thank you. Vivien, on to you.
Thank you, Tommy, for the lovely introduction. Good afternoon, everyone. Give me a second. Let me share my screen. Good afternoon, everyone. I will be enlightening all of you on the law on trespass, the basic law on trespass, and some case laws, including the reliefs and remedies that you can claim when there is trespass. So what is trespass? Trespass is defined as the unlawful entry on a property which is in possession of another. So the Halsbury Laws of England define it as every unlawful entry by one person on land in the possession of another is a trespass for which an action lies, even though no actual damage is done. So a person trespasses upon a land if he wrongfully sets foot on it, he rides or drives over it or takes possession of it, or destroys anything permanently fixed to it, or wrongfully takes anything from it, or erects or suffers to continue on his own land, anything which invades the airspace of another, or if he discharges water upon another's land or sends filth, or any injurious substance which has been collected by him on his land onto another's land. A briefer definition would be trespass to land consists of any unjustifiable intrusion onto another person's land, or someone who wrongfully enters onto another person's land of which he neither has the right or permission of the landowner to do so, or one who goes onto the land without invitation of any sort, and whose presence is either unknown or, if known, has been practically objected to. So in this recent case of Tenaga Nasional Berhad versus Bukit Lenang Development, 2019, 1 MLJ, the federal court judge held that trespass onto land is the unlawful, direct, and immediate interference with the possession of land, which is in the possession of another person or which another person is entitled to possession of. So he refers to the Latin maxim who says that he who owns the land owns it all the way to the heavens and to hell. To put it simply, which is the airspace above the land and also the underground. And this has been coined in our section 44 of the National Land Code, where one's registered title is immune from any challenge one gets to have exclusive use and enjoyment of his or her title. So it states that, subject to the provisions of this Act, any person whose land has been alienated, reserved land, has been leased, or a temporary occupation license, TOL, has been granted in respect of any land, he or she shall be entitled to the exclusive use and enjoyment of so much of the column of airspace above the land and so much of the land below that surface as is reasonably necessary to the lawful use and enjoyment of the land. Take note, there is the caveat here, which is reasonably necessary for the lawful use and enjoyment of the land. So the tort of trespass to land is a tort which is actionable per se, and damage need not be proven for the tort to be made out, which means that if any party trespasses onto your land, you as a landowner has the right to bring an action in court and sue for damages. You do not need to prove your damage. Then we'll now move on to continuing trespass. Continuing trespass is a situation where there is a trespass, you've given the warning, but the trespasser refused to move. So the failure to remove a structure placed on another's land constitutes a continuing trespass. And another example is where, say, landowner A allows B to stay on his land, gives permission that he can use part of his land. But when landowner A sells his land to landowner C, B does not have the right to continue using the land unless B has the express consent, express agreement from the new landowner to use the land. Otherwise, it would constitute trespass. And if he continues to stay, it will fall under continuing trespass. So in this case, the judge explained that the facts of this case is like that. The defendant was in possession of part of a house with a previous owner's consent. Okay, so the plaintiff sued the defendant for trespass, and the court held against the original holder of the occupation license. It says that the defendant was not a trespasser, but became a trespasser as against the plaintiff when the title was cancelled. Similarly, in this case, what happened was that the defendant, in developing a residential and commercial complex, he excavated deep slopes, so encroached onto a neighbor's land, right? And then a new party came into possession of the neighboring land, a new landowner, and he sued the trespasser for trespass. So the Court of Appeal affirmed the decision of the High Court and held that the trespasser was liable for trespass against the new landowner because there was no evidence that the new landowner had given any consent. There was also no evidence to show that the previous landowner had actually given permission for him to stay. If you can look at the last paragraph, it says that it was observed that there was no evidence to show that the previous landowner consented to the act of trespass in any event. Even if there was, it will only be a valid defense, right? If the trespass has ceased when the new owner took possession of the land. So you cannot assume that you have permission to use the land against all future landowners because the consent is only applicable for the existing landowner at that time. So if the landowner has changed to another person, then you need to obtain a new consent. Is there any limitation period for continuing trespass? Interestingly, no, because each day that you continue to trespass, it gives rise to a new cause of action, right? So a fresh cause of action arises from day to day. So there is no limitation period for you to commence a legal suit against the trespasser. So this trespass will only abate once the defendant removes the ground anchors, meaning to stop the act of trespassing. And this is quite a clear principle of law here. So what are the remedies or the reliefs that you can ask the court for against a trespasser? So it is clear that if there is trespass, you can claim without proving your losses. But in such situation, you're entitled to recover nominal damage. By law, you're entitled to sue your trespasser, all right, without proving that you have suffered any damages. In such a situation, you're entitled to recover nominal damages, right? But if you can prove actual damage, such as actual damage to the house, to the land, or if you can prove that had the trespasser not used the land at such material time, you would have earned this amount of revenue, for instance, then that is actual loss. And on top of that, here it says, if the trespasser cynically disregards the rights of the landowner, then the court may award exemplary damages, which is on top of your general damages. All right. And interestingly, in 1988, they coined this principle as the user principle, where you can sue for damages based on the market rental value of the property that was wrongfully used. So say for a period of 3 years, the trespasser has been using your property without your knowledge. And then when you find out, you can sue him. That's your right. You're entitled. And you're entitled to the market rental value of a property without having to prove whether you will have a tenant or not during such period. You are entitled. You can claim the market rental value of that property in such period. All right. And then explained in this case of Ministry of Defense versus Ashman, it was held that there are two types of losses here. Okay. The first is where the loss you suffer is in consequence of the trespass. This is the normal measure of damages in the law of tort. And the second is the value of the benefit which the occupier has received, which is restitution. Like I explained earlier, you can claim two. One is your actual loss, how you calculate, how you prove your actual loss. Then the court gives you restitute, meaning to compensate the losses that you actually suffer. And the court held that these two losses, these two bases of claim, are mutually exclusive, which means that you have to choose one over the other. You cannot claim for both because there would be overcompensation. The principle need not be characterized as exclusively compensatory or exclusively restitutionary. It combines elements of both. In summary, you can claim for the loss of the use of land or the profit that you would have made or the profit that the defendant has made, the trespasser has made by using your land. All right. So the claim for under the user principle, which is the market rental value, is as such. The plaintiff does not need to show that he would actually have let the premises, as I explained earlier. Otherwise, that would be seeking restitution of the defendant's unjust enrichment. So it's two separate claims. And the measure of damages is not what the plaintiff has lost, but the benefit or gain the defendant would have obtained having used of the property. That is restitution. In this very recent case, Lu versus Jabatan Pengairan dan Saliran Negeri Selangor, Syabas, the Court of Appeal calculated damages as such: compensation for past encroachment from the date of the suit to the date of assessment by the High Court, and appropriate annual payment for each year for the continuing presence and use of the land. Because in this situation, it was a public utility, and there was no way for the trespasser, i.e. Syabas, to remove their equipment, to remove their machinery, and etc. So what the court held that, look, because it concerns public utility, it concerns the public, those things cannot be removed, so it has to remain. So how do we compensate the landowner for it? So the court said, okay, in that case, we will order compensation from the date of the court order, which is every year they have to pay a reasonable amount of rent to the landowner, and also compensation for the past encroachment. And then on the issue of exemplary damages, not every court will allow exemplary damages on top of general damages unless you can prove that the trespasser intentionally, despite you giving notice, despite you giving warning that you will sue for trespass, despite you giving warning that's your land, they continue using the land wrongfully, then it is highly likely that the court will order additional damages in the form of exemplary damages to punish the trespasser. All right, so that's the brief law on trespass and the remedies that you can look into if such circumstances arise. So I will now pass the floor to my comrade, Eric, who will explain to you the law on nuisance. Eric, over to you.
Okay, thank you, Vivien. Good afternoon, everyone. Yes, Vivien has talked about trespass, and I'll talk to you about very related cousin of trespass, which is nuisance. Now, nuisance, as we all know in the general English definition, is something that is annoying or something that causes inconvenience. And the law has seen it fit to give victims of nuisance a chance to sue the person who caused the said nuisance to them. So what is nuisance? The definition of nuisance is this: it is an act or omission which is an interference with or a disturbance of or annoyance to a person in the exercise or enjoyment of a right belonging to him as a member of the public. So this is when we talk about public nuisance, which I will give a longer explanation later. Secondly, and more commonly, it is private nuisance. And this is whereby there's an interference with a person's enjoyment of his ownership or occupation of land. So the examples of nuisance are these. We have smells, that is a nuisance, bad smells, speech and noise. Sometimes you have very noisy neighbors. Smoke, sometimes if you, of course, open burning by neighboring landowners is one of the more common examples. So these are the usual things that people will complain about that's caused some disturbance to their enjoyment of their own land. All right, so now I'll talk about private nuisance and what exactly is private nuisance. So as I mentioned earlier, nuisance is something that interferes with the enjoyment of your land, right? And the person who actually causes this nuisance is not necessarily doing something unlawful on their land. So as compared to trespass, whereby, as Vivien mentioned, is something that people come in, disturb, and really do something onto your land. But nuisance is not really. So for example, if I was just having a barbecue in my own house or my own land, but somehow, I don't know, maybe the type of material I use to start a fire causes a lot of smoke, or is something that is really smelly, for example. Then, and if I do this for multiple days or multiple weeks, even after being about, then it could be an example of nuisance and something that would take me to court for. And me having a barbecue on my own land is not illegal, but it depends on what I do and whether that action, that legal action could have caused nuisance to someone else. Other things that could be a nuisance is causing an encroachment onto a neighbor's land, which is almost like trespass, causing physical damage to a person's land or building. And of course, as I said, interfering with his neighbor's convenient and comfortable enjoyment of land. Now, how do you prove nuisance? Plaintiffs, which is the victims, must prove on a balance of probabilities that, number one, there was an indirect interference with the enjoyment of land. Number two, the interference was unreasonable. And number three, the interference must have caused damage to the plaintiff or the victim. So these are the three elements. And for private nuisance, interference will usually have to be continuing rather than a one-off. Usually, but of course, there are certain exceptions that even if it's a one-off thing, it can still constitute nuisance. But usually it has to be continuing like days or weeks, months. And the interference, what is nuisance is an interference which goes beyond the normal bounds of acceptable behavior. And I will explain later with cases of what are examples of what is beyond the normal bounds of acceptable behavior. Then we have public nuisance. So what is public nuisance? Basically, it's something that inflicts damage, injury, or inconvenience on subjects of the state, which means subjects of a country, although it may affect some members to a greater extent than others. So acts which constitute public nuisance are unlawful acts, as opposed to private nuisance, which is like something that you do, which may not be unlawful, can still constitute nuisance. For public nuisance, the acts which constitute public nuisance are unlawful acts. So for example, if you obstruct a highway or you leave some dangerous items on the highway like steel bars, or if maybe you park a car there for a long time, that could constitute nuisance because you're obstructing a highway or rendering a highway dangerous for users of the public. As I said earlier, there's a distinct difference between trespass and nuisance. Trespass usually is a direct entry on land of another person and is actionable without proof of special damage, as explained by Vivien. Nuisance, on the other hand, it can be an interference with a person's interest in property without having to directly enter or entry into the neighbor's land, and is generally actionable only on proof of damage. In other words, trespass generally involves physical encroachments, whereas nuisance will be committed without leaving someone's property. So as I mentioned, the barbecue example, I didn't leave my property, but I can still cause nuisance. So let me just share some case studies on nuisance with everyone. This case is actually nuisance for condo living. So what happened was the appellants sued the respondents for nuisance. The first respondents' unit were directly above the appellant's units. This is a condo. And allegedly, the first respondent renovated his units and turned his units into a student accommodation. And as a result of these renovations, which apparently happened late at night or early in the morning, what happened was there were cracks on the wall, ceilings of the appellant's units. There was also water leakages, unpleasant smells, overflowing of sewage into the appellant's unit. So because of all these renovation, the appellants claimed that they suffered severe inconvenience, disturbance, loss of sleep, loss of use, comfort, enjoyment of their property, mental stress, pain, and suffering, etc., etc. So this is a portion of the judgment. It says that the complaint is noise caused by the unfriendly hours of the renovations, and also with the renovations involving partitioning, electrical, piping, and sewage works. So the other claim for nuisance or ground for nuisance is there was intolerable noise levels from the tenants, because these were students. So the units were renovated and tenanted to students of a nearby college. So there were disturbance from the tenants. But of course, the court in paragraph 77 actually had this thing to say, which is that, look, sometimes you just need to put up with a certain amount of noise, being good neighbors or neighborliness. However, as I mentioned in the beginning, there's a threshold. What is unreasonable? What is an unreasonable interference? And the court noted that the complaints is related to noise and disturbance and renovations which happened at unreasonable hours. Given that the condo is a residential development. So yes, we need to put up with usual noises when we are living in a condo, but not unreasonable noise. And the court finally held that there was the claim for nuisance is proven because of these few factors, these few examples. There were police reports which were lodged at odd hours at night by the victims or early hours in the morning. Logically speaking, if you didn't suffer any nuisance, you wouldn't go to the police station at weird hours, 2 a.m., 3 a.m., and to just make a police report, unless you're a really very strange person, I would say. There were also photos taken by the local council, a warning notice issued by local council to the owners above the victims' unit. There were emails sent by other residents and the other neighbors to the management. And there was testimony by other residents who actually moved out of their own units because they said that the living condition was unbearable. And it's interesting to note also that the court in this case held that it is not necessary to prove by way of scientific or technical evidence that the noise generated was beyond tolerable levels. So meaning to say that, you don't need to bring some gadget and then put that in record and say, it is above this certain amount of decibel levels. That's how you calculate noise. So you don't need to exceed a certain threshold to prove that there is nuisance, because the court saw that there were all these other evidence to show that probably and beyond on the balance of probabilities that there was nuisance to the appellants. And I had another extract here, which basically the court's finding is that the appellant's complaints were not imagined from a real. The noise and nuisance created were not just by the renovations, but by the residents in the 3 penthouse units, were of such volume, intensity, persistence, or regularity that any reasonable standard will consider such conduct an acts complaint of a nuisance. So you see here, there is unreasonableness, as I mentioned in the beginning. There's unreasonable noise, and then in volume, intensity, and also the court noted that there is persistence or regularity. It must be continuing, so it happened continuously, so it is a nuisance. Now go on to the next case. This is actually a case that is a mixture of trespass and nuisance, and I'll tell you why. Because in this case, the plaintiff complained that the defendant, who is his neighbor, caused nuisance to his land because of a few factors. Number one, there was soil erosion and landslide on his neighbor's land, and his neighbor failed to provide a proper drainage system in his own land. So it is noted that neighbor's land was higher than his land, of course. So when it's higher, when it rains, then inevitably there will be some soil erosion or landslide if you do not have a proper system to prevent that. So as a result of this soil erosion and landslide, the plaintiff's land was affected. The plaintiff also complained that the defendant failed to maintain or prevent trees in his land from overgrowing and falling into place into his land. And also the defendant had brought, so these are trespass, right? It's mixture. So because some of the items or soil has actually encroached physically into the plaintiff's land. So then another part is that the defendant brought into his land large scrap metals of motor vehicles, which is piled up close to the plaintiff's lands. And the plaintiff said that, this causes or could cause serious harm or risk to the occupants on their land, where it may fall over or whatnot. So the court held that, yes, plaintiff was able to prove that defendant committed the nuisance. Plaintiff suffered damages to his drains, fences, pipes because of the soil erosion and the landslides. And plaintiff also constantly faced danger from the piled up scrap metal next to his land. So in this way, it's also an interface of enjoyment, because you're looking forward. This thing will fall on me anytime soon. I'm not going to go nearby that boundary because I'm worried that something will fall on me. But then that means I cannot, that's interfering with my enjoyment of land. So that is nuisance. So what happened was the court looked at it and said, okay, fine, why don't both of you equally bear the cost of constructing a retaining wall? So the retaining wall will prevent things from falling over. So you keep the trespass and nuisance from happening. And it's interesting that the court also said, okay, you know what, defendant, you're not allowed to sell your land until you complete this construction. It's to prevent the defendant from running away. It's like the court asking you to build something, but then, okay, you know what, I don't want to build, I'll just sell my land and leave it to the next landowners problem. So the court said, no, you cannot do that. Of course, then the court also granted damages for the plaintiff because he needed to clear debris, he repaired his drain, etc., etc. And also, the court also actually gave exemplary damages, which is not totally common. But why the court gave exemplary damages? Because on evidence, the plaintiff had many times attempted to communicate with the defendant and say, like, hey, solve this. How do we resolve this? But apparently the defendant did not want to cooperate. So the court took into account and gave a sum as exemplary damages. We come to another case. This is about inconvenience, whether an inconvenience is nuisance. So in this case, the appellant bought a house at the housing estate. And when it was purchased, it is part of the gated and guarded community. So there was already a boom gate guard house, which on the road, which served as the entrance and exit, which is quite common. The resident association, of course, they have to collect some money to maintain and pay the guard to take care of these boom gates. But the appellant did not pay, apparently, did not pay the monthly security charges and maintenance charges. So the resident association decided that, look, if you don't pay, then you have to open yourself. You open the boom gates yourself without the assistance of the security guard. So the appellant, of course, not happy with this, sued the resident association and said that there was a nuisance. Among other things, there was a nuisance in creating obstruction on public road because of the boom gate. So the appellant also sought that the boom gates and the guardhouse be demolished. The appellant lost at the High Court of Appeal, and the Federal Court held, among other things, that the appellant's complaint is a complaint of inconvenience and not of obstruction. And you cannot sue for nuisance for an inconvenience. And because the court said that, look, individuals, we live in a community, and it's always the balancing of the individual's inconvenience against the community's interests. So one person against the many. And in this case, it weighed against the individual because the community, security of the community is more important. And the Federal Court agreed with both the High Court and Court of Appeal. And in this case, this is a nuisance of smell. Washington development is a nuisance of smell. So the court said that actions which constitute nuisance can be sound, smell, vibration. So what happened in this case is the plaintiff neighbor is actually runs a pig farm. So when so obviously there was some stench coming over from the pig farm, plaintiff obviously sued for nuisance. And the judge, when visiting the plaintiff's land, also noticed that there was a strong smell coming from the defendant. However, even noting that there was a strong smell, she did not find that there was nuisance. This is at the High Court. So the court said, no, this is not correct. Since she has found there was a strong stench coming from the defendant land, failing to find that there was nuisance. And the Court of Appeal said that there was a breach of a license. There was a license conditions that the defendant must plant trees to act as a buffer to prevent smells from reaching the plaintiff's land. So the defendant did not do that. So because of that, because there was no trees there, the smell would come over. And although the pig farm had existed before the plaintiff's development, it does not give the defendant the right to commit public nuisance. So basically, the court is saying that, look, even though you knew that there was something happening on your neighboring land, which may be a nuisance, it doesn't give your right to your neighbor to continue with the nuisance once you come in. Just because maybe the previous landowner didn't say anything about it, doesn't mean that I, as the new landowner, am okay with that nuisance. In this case, it's a stench. Court of Appeal then said, okay, I grant an injunction in the following terms, which is to stop the defendant from continuing with the rearing of pigs in their land, so to stop the nuisance. But the court did not grant damages because it was not proven that what kind of damages the plaintiff suffered because of this nuisance. Okay, now I come to public nuisance. So just now it was private nuisance. Those were examples of private nuisance. You have the smell, you have your sound, you have your inconvenience, which is not a nuisance. Now we come to public nuisance. So as I mentioned before, public nuisance is a nuisance that causes trouble or interference with the general public. And in this case, the plaintiff claimed damages for personal injuries as a result of an accident on the road or a highway. So what happened was, the plaintiff, in trying to avoid a child crossing the road in front of him, he had to swerve his motorbike and he crashed into a steel pipe which was left lying about 3 to 4 feet from the side of the road for 1 or 2 years. And as a result of that accident, the left leg of the plaintiff had to be amputated. So what happened was then he sued the defendant, who was the person who left the bars on the pipes on the road. And the High Court held that, yes, the defendant was fully to be blamed for leaving all these dangerous items on the road. Among other things, the Federal Court agreed with the High Court. And on the second bullet point there, the Federal Court said that, look, highway is normally used for passage. And if the defendant left a nuisance so close to a highway and it was extremely likely to cause injuries, and it was the nuisance which caused the injury to the plaintiff, then the defendant cannot say that, look, it's not my fault that the plaintiff was injured because he was avoiding something else and then hit into the bars that I left on the road, which caused the injury in the first place. So the Federal Court did not agree with that and said, look, as long as you left something on the road which will cause danger, and it was left there apparently for I think 1 or 2 years, then you are liable. So just because people hit your bar or steel pipe because they were trying to avoid something else doesn't mean that you are absolved of liability. So what do you get for nuisance? So I think as you can see from the case examples that I presented earlier, you either get injunction or damages or both. So injunction meaning like to stop someone from doing something, and of course damages is money. So here I put some examples of injunction. One case here, the court granted an injunction to stop the appellant or the organizer from operating or permitting to operate music bands with singers from open air stage, because this is noise again, because it was very noisy to the neighbors. So the court said it was a nuisance. It granted an injunction to stop them from continue having music bands. The case earlier about the pigs, there's the smell. Then there's another case, of course, this is about fumes, dangerous fumes coming from, I think it was a clinic that was, I think, below the unit of the victim. So said there was some fumes because of the nature of the operation. There's noxious fumes coming up from the neighbor or the unit owner below, and it caused a lot of health issues to the plaintiff. So the court held, okay, I'm going to give an injunction, which is to stop the unit owner below from continuing with the nuisance. So you must stop emitting all these fumes because it caused injury. And of course, then we have the damages. In addition to the cases that I've already explained earlier, we have, so the first one will be the one for clearing debris, damages to pipe, etc. And then there are other cases, the one about the noxious fume. So in addition to injunction, the court said, okay, I'll give you another 40,000, because I think that was because they could prove that they suffered injury to their health due to the noxious fumes. So that is the nuisance. So these are the usual remedies: injunction to stop something from happening, continue to happen, and then damages if you indeed suffered some damage, and if you can prove that you suffered damage due to that nuisance. Okay, I will pass it back to Tommy for the question and answer section.
Thank you, Eric. Thank you, Vivien, for your wonderful insights on this topic, landowners' rights against trespass and nuisance. We will now take questions from the participants from the Q&A chat box. So we can begin with the question of damages for trespass, as you said, in getting evidence. Was it in the form of CCTV footage? How about witnesses? I think this will be addressed by Vivien.
Thanks, Tommy. To answer your question, any evidence can do, because if you don't have a CCTV footage, it can be pictures. If not, then it can be witnesses who saw the trespass. So any evidence would suffice, not necessarily in the form of footage. So I hope that clarifies.
Thank you. Moving on to the next question that we have. In the case of my neighbor who had conveniently and selfishly fenced up the common back lane at both ends, his unit is the end unit with his side of the building facing the main road. Doing so, he had blocked the path of escape in the event of fire. Under which act of law can I compel him to remove his fencing? Who should I file a complaint to? Vivien, I think this is to be addressed by you.
Mr. Fu's inquiry. Okay. This is a common problem amongst neighbors where they renovate their properties and then it affects other neighbors. But here it seems that it's affected the common right of way. So in most cases, you have to lodge a complaint with the local council because it's likely that his fencing or his renovation has not gotten the necessary approval. So number one is to lodge a complaint with the local council. Second, you can get a lawyer to issue a letter of demand against him for disrupting the use of the road, especially as you mentioned, fire hazard. That is what you can do.
Thank you, Vivien. Again, I hope that answers your question, Mr. Fu. Moving on, we have one anonymous participant who has asked on private nuisance. What about cigarette and cigar smoking on a balcony of a stratified property, i.e. the fumes keeps going over to the neighbor's unit? Eric, I think this is your areas of expertise.
Yes, thanks, Tommy. Yeah, I think we have all people who live in condos or stratified properties who know or can experience these things and have cigarette butts flying down from other units and burning your laundry as well. So that happens. But I think, sure, there will be private nuisance. But the only difficulty here is whether you can prove where did this cigarette come from? Where did this smoke come from? In terms of I think the case I mentioned earlier, there was this noxious fumes, right? So it was clear that it came from the unit below because I think it was another clinic. It was a clinic or something. So one of the chemicals that we're using caused these fumes, which went up to above a neighbor's unit. So that's very specific because how the chemicals are quite, I think, easier to be spotted. But if you're talking about cigarettes, unless you can show that, oh, this fella here that is smoking, maybe you have videos, you have pictures, sure. But again, it also boils down to, the second thing is, it also boils down to reasonableness. Because unfortunately, we have to, for non-smokers, you have to tolerate or live with neighbors who smoke. That's just living with other people. Unless you're saying that he chain smokes, or he or she chain smokes and put like all the 10 or 20 packs and then put beside in the balcony and it blows it over to your house for some reason, then that's unreasonable, perhaps. But if it's just smoking, then unfortunately it's something that you may have to live with. Just like noise, we live with a certain amount of noise levels from our neighbors. Yeah.
Okay. Thank you, Eric. I think that is there's a very detailed response at alleviating the stress of smokers and cigar smokers as well. Okay, the next one being question from Miss Doreen Chow. What happens if there is a right of way? I will pass this to Vivien to address.
Hi, Doreen. I assume you're asking what happens if there's a right of way in terms of whether you have a cause of action for trespass or any wrongful interference with a right of way. It will fall under nuisance. But you have to prove that the interference with your use of the right of way is to an extent that it will affect your use of the right of way. So say your neighbor has used the right of way to his own advantage, but by doing so, he has stopped you from using the right of way as well. Then you have an action against your neighbor under nuisance. Eric, you have something to add to that?
No, actually. I think, yeah.
Okay, I hope that helps, Doreen.
Thank you. Wonderful. Okay, I think we are on crunch time. Let's get a question more or two. The next one being a question from Mr. Fu Chi Thong. Would the owner of a particular car, which is abandoned but parked at the housing estate for a long time, this would deprive other residents for use of the public car parking, roadside parking? In this case, what violation of law does this constitute? Eric, maybe?
Yeah. All right. Okay, so this seems like public nuisance kind of issue because if you talk about public car parking, so it's not private. So because it doesn't interfere, because you don't own it or anybody else from the housing estate doesn't own that car park. If you're talking about public car parks, so that one will be a public nuisance. So I think what you can do is you should just complain to the local council and get them to tow the car away, especially if it's been there for a long time. So I'm even aware that there are certain cars, even in our office, there was this taxi that was parked in the car park for however long since I've been here, and it is always made already dust accumulate, the tires already deflated, it's still there. So I think what happened was the management office, they called the local council, they sent a tow truck and tow the fella away. I think hopefully it's not there already. So I think this is what you can do if there's such an abandoned car in your housing area or near your housing area.
Thank you, Eric. Thank you. I think we still got time, so we'll go on a case-by-case basis. The next question that we have is Mr. Chan Chi Chai. Dear speaker, good afternoon. Do you have cases where the JMB or the management committee is the plaintiff against adjacent neighbor for causing nuisance? Thank you. I think the speaker here in question is Eric.
Okay, so I think this is a bit, depends on what you are talking about, what is the circumstances, because, okay, I think the JMB and MC, off the top of my head, I don't have a specific case in mind, but I'm thinking that if you're a JMB and MC and a nuisance is perhaps a neighboring land owner, like what happened in one of the cases, their land's higher, or they, things they did cause some landslides to the whole condo as a whole, then yes, I think the JMB and MC can be a plaintiff, because the JMB MC represents the whole development. So if there's something that caused by your neighboring landowner and cause some damage to your common property, parkings or your trees, the facade of the whole condo, then sure, your MC can be a plaintiff. But if you're talking about just specifically if there's unit disputes, a dispute between the unit owners in your own condo development, then unlikely that you will be a plaintiff. However, you may be a defendant if one of your unit owners complain to you that it's just like the first condo case I mentioned. The appellant, they complained to the management office and said, look, there's this noise coming from the neighbors. There's this illegal partitioning, illegal renovations. Please do something about it. But the MC didn't do anything about it, or did not do enough. So they were sued as third or fourth plaintiff, and the court did grant damages against them as well. So it will depend on what is the situation, what kind of nuisance you're talking about.
Okay, thank you, Eric. I think I'm a victim of nuisance myself. My neighbor is drilling upstairs. Don't know if any of you can hear. Okay, I think there's a follow-up question by Doreen to her initial question. Land sold by developer and hence there is a new landowner. The road to enter condos was given right of way. New landowner, being the developer, is in the opinion that maintenance of that road should be done by the JMB of the existing condo. The worry is, would it be deemed as trespassing? I think this will be addressed by Vivien.
Hi, sorry, Tommy, can you repeat the question again?
Okay, so Doreen asked on the previous question, supplementing it with this. Land is sold by the developer and hence there is a new landowner. The road to enter the condo was given a right of way. The new landowner, being the developer, is in the opinion that maintenance of that road should be done by the JMB of the existing condo. The worry here is whether or not that would amount to or be deemed as trespassing.
Based on the brief facts that you have given to us, it does not sound like it will amount to trespassing, because the right of way is for the condo users, and any maintenance of the road, which is the JMB's duty, is just it's to elevate the enjoyment of the right of way. I do not see how it will fall under trespass.
Thank you, Vivien. Okay, moving on. I think we got time for one or two more, then we have to wrap up. Okay, from Mr. David Cheong, about one's case studies of nuisance on renovation for rental to students. In that case, can the management of the condo be sued for not practicing the right rules? In fact, the management and security guard of the condo should have stopped it from the beginning. I think this is for Eric in terms of nuisance.
Yes, I think I just mentioned earlier that indeed the management corporation was sued in that case, part of the defendants. And if I remember correctly, I think a damage in the sum of 10,000 ringgit was actually granted by the court against the management. So the management corporation had to pay 10,000 for the damages that were suffered by the appellant. So yeah, so importantly, if you are part of the management corporation, please do necessary. Please take complaints seriously, especially when you have nuisance like this or trespass, when you have landowners or unit owners complaining about leakages, complaining about sewage coming into their units, noise. Yeah, I think you should take it seriously, because you never know when you will get sued, and then Once if you're sued and then you need to pay for damages, then you have to explain to the rest of the unit owners why the management corporation, or why the money that is paid to the management corporation is having to be paid as damages due to your lack of work.
Thank you, Eric. Okay, we've got time for a last one. This question is regarding, there are situations wherein a developer buys land and there were illegal squatters on the land. The illegal squatters were there since the beginning of time. Rather than the squatters being made to pay compensation, the developer had to appease the spirits by paying compensation to the illegal squatters. The weird turn of events that defy the laws of the land. What are your views on this? From Christopher Chan of Laurel Cap Group. Vivien?
Hi, Christopher. A very lengthy inquiry, but the short answer to that is that the courts have taken the view that illegal squatters are trespassers and they are not entitled to any compensation. In fact, orders have been given to them to evict them from the landowner's land. So in your case, if you're talking about compensation to appease the spirits, I'm not particularly sure in what circumstance compensation was made, but if the court did order such compensation to be ordered to illegal squatters, then it is likely that the court finds that there was some consent or license given to these squatters from aeons of years ago. If court sees that there's evidence of such permission being given many years ago, then likely they will order some compensation to be paid. Otherwise, the law is quite clear that they are not entitled to any compensation and they have to leave the land upon the court ordering them to do so. Hope that helps.
Thank you for a detailed answer, Vivien. With that, I would like to conclude our Q&A session. And if you have any follow-up questions, please feel free to drop us an email or inquiry and our lawyers will attend to your queries accordingly. So before we conclude, I would have a few announcements to make, and I would like to thank Vivien and Eric for their time and insights. So please allow me to quickly share my screen. First, please join us again for our upcoming talk on the 16th of November 2022, which will be on the subject of Malaysian citizenship, how the federal court in CTEB and CCH has changed citizenship rights. Very interesting topic to be presented by our Miss Jasmine Wong and again, Mr. Eric Toh. Secondly, please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat. Thirdly, do follow and like our social media accounts. They are very interesting and they have wonderful insights as well. Fourthly, if you would like to speak with our lawyers, we offer a complimentary 30-minute video consultation over the telephone or over the video conference, i.e. Google Meets or Zoom call. Please fill in the form in our website. The link is posted in the chat box on Zoom. And to our guests today, thank you for joining us. We hope you have found today's session informative, insightful, and useful. Thank you, everybody. Have a great evening ahead and see you at our next talk. Thank you.